Welcome to the ISA Conference Rewind series. I am Tanisha Price, Instructional Designer at the International Society of Arboriculture. Today, ISA is happy to bring you Did We Keep That Heritage Tree Too Long? By Mike Garvey. This presentation was originally given at the 2020 ISA Virtual Conference, and the views and information expressed are those of the presenter. Now, sit back and enjoy the video.
Greetings from the Big Sky state of Montana, and welcome to my presentation, Did We Keep That Veteran Tree Too Long? The ISA Municipal Specialist Certification Study Guide states that deciding whether to remove or retain an old tree involves making decisions about the willingness to accept risk of damage or injury should the tree fail. The city of Billings, Montana decided they were willing to accept the risk of a large mature tree in this picture that was situated in a public park in near proximity to a frequently attended playground. The tree caused significant and severe harm when a large diameter branch fell out of it and hit a person who was sitting on the lawn underneath its canopy. Subsequently, the city was sued for negligence, the plaintiffs arguing that the city knew or should have known that the limb was in imminent danger of failing. I was involved in this case for the duration of 2.5 years. And as a consultant and an expert witness, the case was resolved last December and is now a public document. So what I really want to talk about is not so much a case study in analyzing the defects of the structural condition or loads that may have caused this limb to fail, although that was very important. But I rather chose to look at the communication breakdowns that was really directly affected this case. It affected how the case unfolded over time, sometimes negatively, in the city's defense of this case, and how communication breakdown really caused some trouble and stress for some of the arborists involved as the case progressed and actually ended. In our words and our actions, as arborists, sometimes I think we don't think about what we're saying and what we're doing. We don't get to practice that very often. So it's a look at communication breakdowns, and I'll start off with setting the table, the background information of this scenario. And then I've broken this down into some of the management of this subject tree prior to the tree failure incident. The protocols for managing and protecting the evidence immediately after the tree failure. This was a big part of this case. And then wrap that up with showing some examples how this can be really tough to defend their management decisions and credentials when required to provide sworn testimony. How I came to be involved in this case. About a week after the incident, I was retained by the City of Billings Parks Department to write an independent and objective visual tree assessment for this tree. I was not asked to offer conclusions or opinions on why the subject limb broke, but I was asked to make some recommendations for either retaining or removing the tree. The plaintiff's attorney used my report to bolster her claim that it proved, my report proved that the city was negligent. And they didn't do enough, as you can see in this newspaper report clipping, that the city didn't do enough to ensure the tree was safe, citing a report by an arborist that after the branch fell, recommending removal of the tree. Suffice it to say that the plaintiff's attorney misinterpreted or misread my report. I did not recommend removal of the tree because this branch fell. I offered some retention options, but the city decided to remove the tree because at that point, they were not willing to accept any consequence of failure. So the subject tree was a Plains cottonwood, Populus sargentii, located in Veterans Park. It featured a 74-inch stem diameter. It was approximately 30 meters tall. At the bottom of that photograph, the red arrow is pointing to my trusty yellow field bucket, which measured the height at 100 feet. It had a 100-foot isodiametric crown spread. There was no history of prior failures with this tree. It was pruned 5 years before the limb failed. Now, including me, there were 7 arborists who were deposed in this case. And we were all asked about the age of the tree. And those figures came in anywhere from 75 to even greater than 125 years old. This was a really important part of the case on the plaintiff's side, because they argued that the city was negligent for having just this really old ancient tree in close proximity within fall distance of a popular playground. And I'll talk about how the age came into play in a few slides down the road here. So I should start off a month before the limb failed. And this did not directly affect the case, but indirectly it did. The city of Billings had hosted an Arbor Day event in Veterans Park. And as part of that celebration, they used this cottonwood tree to set 10 climbing ropes so that several hundred kids could climb that tree. Now, there were no failures, there was no accident, no one got hurt at this time, but it came out in evidence that the city, there were 2 city arborists and 2 private arborists who set this climbing event up, that there was not a tree risk assessment done prior to this event. And the start of the communication breakdowns, the private arborist thought the city arborist had done the tree risk assessment, and the city arborist thought the private arborist thought they had actually done the assessment. And the plaintiff's attorney used this as kind of a starting point that the city is just negligent. They're missing the standard of duty. No one would have all these kids climb a tree if you weren't really taking care of it and looking at it and make sure that it's stable. Now, these photos, and all the photos and images, by the way, were entered into evidence, shows the event. The yellow arrow and the red arrow that I've inserted shows the approximate direction of where the limb would have fallen a month later. So the scenario, the night of June 2nd, 2017, the day was warm, dry, and calm. You see a picture of people underneath the shade of the trees. And I repeat, people underneath the shade of the trees. And I repeat that because having people underneath the shade of the trees in a public park actually comes into play in this event. And I'll talk about that a few slides down the trail as well. But people were waiting for the sun to go down. The city Parks and Rec were offering a free outdoor movie at Veterans Park. I will note that the months of April produced above average rainfall for Billings. Normally at the beginning of June, we roughly have 6 inches, 15 centimeters of precipitation. Going to the night of June 2nd, we actually had 8.85 inches of precipitation. So approximately about 7:30 in the evening, a 50-foot long, 20-inch diameter limb suddenly breaks out of this cottonwood tree. The yellow arrow is pointing to where the actual break was. Now, as you can see, as that limb was falling over, it's actually got cut up in a fork just below it, which took a lot of the force of the fall from that limb away, and which was a really good thing for the gentleman that got hurt. Most people believe that if that limb had just fallen out and hit him directly, that he probably would have been killed. Before I go on to the next slide, I just would like to mention this photo right here is a really good example for those of you who write tree risk assessments, level 2 assessments. And we're asked to come up with that risk rating matrix and all these little cells that are divided by these lines, the consequences of failure from minor, significant, and severe. There's a lot of gray area between those black lines. It's really hard to predict what the injury will be. It's hard to predict the mode of failure. It's really difficult to predict on if a branch falls, what are the consequences. So rare and devastating images of tree failure. These photos were taken immediately after the tree fell. First responders get there. And I didn't insert these as to sensationalize this talk. The photos were certainly going to be introduced in evidence in a court hearing. But it really shows, when we talk about risk, and the definition of risk is being this combination of a likelihood of an event and the severity of the consequences. And that's really an abstract thought. So what you're looking at here are vivid images of risk realized. So risk, instead of being this benign noun, is now an active verb. And you see these young children, I believe they were the children of the gentleman who actually was hurt, and fireman's doing his best to get, just then get them out of the way. These vivid images really counteract all the benefits that we talk about that trees produce, all these wonderful benefits. And the tree risk assessment manual, ISA's manual, states that some level of risk must be accepted to experience the benefits that trees provide. And I agree with that. Most of my people I know, the clients and customers I have, will agree with that, especially when you show them all this in the middle here, all these wonderful facts that the trees in public parks and buildings were producing. But when you compare that to these images here, people's attitudes toward trees change. I would not want to be the person defending this action and saying, oh yeah, well, this guy got hurt really bad and his kids are really, really terrified. But look at this, we have 113,000 pounds of carbon dioxide sequestered in Billings. The advent, the happening of risk changes people's attitudes. And here's how it did in this case. So as part of a consultant and expert witness on this case, I was given roughly 3,000 documents, included a lot of pictures to go over. And this piece of metadata really caught my eye. And what it is, it's a GoFundMe page for this gentleman. And you can see that picture of him in the hospital, and he was hurt really bad. His lung was punctured. He broke 3 of his ribs. He got infections because of it. But I've underlined this, hope you can see it, the evil tree. They're talking about the evil tree. So this was really a beloved tree, a community tree in Billings, probably the largest tree in our public parks. Within 48 hours, this tree is now referred to as the evil tree. And my thought being is that if that's the evil tree, what do they think of the people who are actually taking care of that tree? Now, on the complete other end of it, I cut this article out of the newspaper. I'm an old school guy, and I actually like holding and reading newspapers, but a little over a month after the incident, I cut this out, and this was before I was retained in this case. This article was not introduced into evidence, but it really caught my eye. A guy by the name of George, and some of the things that he said just astounded me. He states, I'm offended that the city cut down the tree in Veterans Park just because a branch fell on some guy walking under it, or so he says. He was probably hanging on it and it broke. I see no reason why a 100-year-old tree should be killed just because a branch fell on some guy. This is the arena that we're really dealing with as tree managers. Two polar opposites of perspective on when trees fail and hurt people, and they're both irrational. One, you're now blaming the tree, the other, now you're blaming the victim. Where this can really come into play in a court case, if you have some people who have these feelings get seated on a jury that's basically going to decide the verdict. So sometimes it doesn't matter. You can have the law behind you, you can have all the facts behind you. If a jury sees something or feels something really, really negatively one way about a tree, that can really alter the verdict. Okay, so I talked about the first part of it, I want to just go over some errors, some mistakes, very honest errors and mistakes in terms of communication, that process of conveying information between and among people before the tree fell, before the tree limb fell. So in Billings Parks, the city of Billings has no had no tree management plan, still does not have a tree management plan. Big mistake. The plaintiff's attorney really pounded the city on that. But they did compile a complete park tree inventory in 2011. And all of those 8,335 trees were pruned within a 5-year cycle. Now, the city of Billings aimed for a 7-year cycle, and they actually finished it in 5 years, which you would think is a good thing. The plaintiff's attorney argued that, well, you just rushed through your job. You really weren't doing a good job. And because of that, my client got hurt. You can't make this stuff up. However, in Billings, we have roughly 115,000 people in the city. 2 million people annually enjoy our parks. We've got a lot of really nice public parks. People like our parks in Billings. And there was no evidence at all of any injury caused by a tree failure reported in a city park. So the city did operationalize the tree inventory, and they prioritized some of the largest trees and those trees that were in really close proximity to frequently used areas in the park. And they sent out a scope of services, a request for what essentially was crown cleaning. However, the person who wrote this slipped in this word hazard tree pruning and hazardous trees. And during deposition, this person really got grilled on this. The line of questioning went like this way. So what's a hazard? What's a tree hazard? Well, a tree hazard is a likely source of harm. Oh, really? Well, I'm looking here and you have 87 hazardous trees going up to 63-inch diameter. In fact, it was 74 inches if you include the subject tree that I'm talking about. And how did you let them get hazardous? Were all the hazards pruned out of this tree? The reply was that, well, it was crown clean. Most of the hazards, dead, dying branches, broken branches, maybe diseased branches, hanging branches were removed, but we don't know. So the question was, did you ask, this was all sublet, to a private tree company. Was in your scope of services, did you ever mention that if this company is up in this tree and if they see something that they should report back to you? And it wasn't. So note this, that the last person in the tree is probably going to be the first person who's going to be asked questions about what happened if something bad happens to this tree. And the question that the plaintiff's attorney posed was, is there a duty for arborists to report concerns they may have that are not directly related to the work they are to perform? Now, these two photos were taken by the city forester at the time. They were pruned in August of 2012, which was a good deal. I advise anyone in arboriculture to take as many photos of the work that you can. It's very useful. It's easy to do anymore. It can really come back and save you in a pinch. So in the left photo, the arrow showing they had a climber going all the way to the top of that tree. They also had a person in the bucket, and they had 2 grounds people. And they were called into deposition. The foreman was actually called in to provide deposition. And he was asked about these hazards. Is that, so you're pruning hazard trees. Did you remove all the hazards? Well, we removed what we were told to remove. And in this photo on the left, on the right, where the yellow arrow is pointing, that's an old lightning strike, an old injury, which would be a hazard. And the question was, well, if that's a hazard, that's a likely source of harm, how come you didn't remove that? So in hindsight, it might be for municipalities a good idea to consider having some sort of language in a document in the specifications that says, if you see something, you're up there looking down, we can't see this from the ground, just let us know. On the flip side of that, if you're a private arborist, that puts a lot of heat on you that, yeah, now am I responsible now? I wasn't responsible for doing, taking care of for instance, this lightning strike. It seemed to be healed up and it was fine. So this is a really sticky matter. And I don't know how that's going to get resolved, but I really think that in the future that for people who are writing specs should think about how that could unfold. So I talked about negligence and duty, and just to clear up a few definitions, the duty and the standard of care. The duty is our obligation and responsibility. In this case, it's the care of trees. Negligence and a breach of duty are very similar. It's a failure to use reasonable care or failure to act in a reasonable way. The standards are the documents that operationalize or, form this recipe on how the work is to be done. The standard of care, this concept came up a lot through this case, and it's an idea that I don't think a lot of arborists think about daily, and it's really important to know. The standard of care is that degree of care which a reasonably prudent person should exercise in the same or similar circumstances. Now, the plaintiff's attorney had argued all along that Billings, in particular, their tree risk assessment or lack of tree risk assessment for all the trees that were included in the inventory had failed the standard of care. Of note, though, a universal standard of care has yet to be defined for a tree risk assessment. Okay, words and actions before the tree fell. And this is a classic example of just a failure of communication. And I should start by saying that the person who wrote this was a former arborist and city forester for Billings. And this person did more than anyone in Billings to promote arboriculture, safety among trees, urban forestry, getting kids interested into trees. He made a classic mistake of communication, not to take away from all his credentials. I still wish he was actually back in Billings, but roughly about a month after the pruning was done, he posted a picture of that pruning on a website, in the City Parks website, on a page that he had, Tree of the Month article. And at the very bottom, I've underlined his last statement. He says, "Come and join the shade in Veterans Park." So it goes back to that picture that I mentioned, that people are underneath the shade of trees in public parks. The plaintiff's attorney argued that the people in the public parks were now considered guests because they were invited to enjoy the shade in Veterans Park. What provides shade in parks are trees. And so now, not only are you negligent, you don't take care of your trees, you're actually inviting people into a dangerous zone. So you're like doubly negligent. That's not a legal term, so don't quote me on that. But he got in hot water on that. More importantly, he makes a few statements about cottonwood trees, and he says they can live well over 100 years, but often begin to fall apart and die out really fast. And this one statement here really caused a lot of heartburn, actually, on the defense side. And he says that cottonwood trees are beautiful trees that provide tons of shade, but do not make for the best trees around houses and playgrounds. And I'll talk about how he was questioned on that later on in my presentation, but I can guarantee you that the plaintiff's attorney jumped all over this as evidence that this is just negligence. Why would you're saying right now that this species of tree is not good to have around a playground, and yet you have a really big one that's in really close proximity. Okay, a few items after the tree fell. in terms of breakdowns of communication, spoliation and the collection of evidence. So spoliation is a legal term, and it refers to the intentional, reckless, negligent hiding, withholding, altering, or destruction of evidence that would be reasonably anticipated to be used as evidence in a legal proceeding. Now, you'll recall that as the limb fell out, it actually didn't fall all the way to the ground. It got hung up in that fork beneath it. So very early the next morning, the city arborist and his crew were directed to get the limb out of that fork, lower it to the ground, and then they were directed to actually get rid of it. So it was cut up into rounds, it was chipped, it was hauled to the dump. At no point was there any evidence that anyone in the Parks Department had contacted the city attorney's office and said, hey, someone got really, really hurt here last night. We have this large limb on the ground. What do we do with it? It's a breakdown in communication. Now, the city arborist, however, took some pictures of this. This is the best picture of approximately where that limb snapped off. And you can see on the lower part of that limb that there's a fairly decent pocket of decay there. And that would have been on the top side, on the tension side on that limb. You can see that it was a live branch. It was a live limb, and live branches and twigs all over it. There are penalties for spoliation, some severe penalties for spoliation. In this case, the plaintiff's attorney petitioned the court for a summary judgment before the trial even began, because she was denied the evidence that she needed to, represent her client in the fullest way that she could. And I'd have to agree with her on that. I would have actually liked to seen this piece of information right here, because it could help explain what happened. It could also help defend the city in some ways. Again, if this was on the top side of this branch, you can't really see it. You've got all this live foliage around, but you can't get rid of this evidence. And so the city arborist did take some pictures on this. And again, he was fulfilling, the standard of care. It was his duty there, because he was asked at deposition, why did you take these pictures? And he said, well, we were getting rid of this. I was told to get rid of this, and I thought they might come in handy. Do not whether you're a city arborist or a private arborist, when a limb falls and causes severe damage, in particular to a human being, do not get rid of this evidence until you seek some legal counsel. So process of documentation, what's in your management plan for tree failures? As I mentioned, the city of Billings did not have a tree management plan. So although the plaintiffs were denied the lion's share of the evidence, it was agreed that the plaintiffs could have any portion of the tree, of that limb, that they wanted to. And so it was cut down. Now, the yellow arrow in this left photo is actually pointing to an old pruning cut. And this is really important to the case, because it's actually on the top side of that limb. It is very hard, and this is about 35 feet, 10 meters in height. And on that top side, it was really hard to look at and actually spot this from the ground. Now, the plaintiff's attorney had argued all along that this, in fact, was the point. This defect here was the reason why this limb broke. And so they got it down to the ground, and the red arrow in this photo on the right is pointing again to that old pruning site. Now, what's really interesting was the attorney, and she's actually in this photo, she's second to the right in this photo, had complained that the evidence was destroyed, but all she wanted was this top part where that section was cut. And the city had no interest in keeping the part below it. And again, this is a breakdown in communication. There's no evidence that the city attorney's office was asked, what should we do with the rest of this evidence? So they made the cut. And at the point that they made that cut, at that point, in my view, this whole piece of evidence, it actually should have been weighed. For one thing, the plaintiffs are arguing that the limb was just too heavy to support itself. It should have been measured and it should have been photographed on all sides before it was actually moved from the site. Here's the reason why. So the photo on the left is the photo that the arborist took, aerial photo, before he actually cut it. And what you see there is not a cavity. Now, the plaintiff's attorney all along kept referring to it as that old cavity. And in fact, she had several of the arborists who were deposed to refer to it as that old cavity. And they didn't correct her that, you know what, as an arborist, that's not an old cavity. That's an old pruning cut that is surrounded by, and I measured this, another 4 inches of highly lignified supporting wood. So as it was cut down, the middle photo shows that it probably, and I wasn't on site at that point when they lower this to the ground, probably swaying a little bit, hit part of the tree, hit the ground hard a little bit. So some bark got bounced off of that. But now you look at that old pruning site and you can see the remnants of the original lateral branch there. And yeah, you can see some space that encircles that lateral branch. Photo on the right shows it as it was finally transported to a secure storage space. And whatever happened to that small branch that was in there, no one knows. The evidence was just gone. And you can now see that that is an old cavity, but it wasn't an old cavity that anyone who was managing this tree before that branch broke. And so it's really important when in the cases when you have to preserve your evidence is really not think so much like an arborist, but think like a detective, investigative journalist, and just document everything, photograph everything that you can. And here's what happened. So as it was put in, as this piece was put into this storage center, it was actually the bottom part, the cut part was left, it was standing upright. And so these photos were taken roughly a year after that it was actually put into the storage unit. Now, as we turn that over to look at the backside of it, and the plaintiff's expert witness really wasn't interested in seeing that too much. And they were afraid, the plaintiff's side was afraid that if we turned that piece over, it was just going to disintegrate and fall into dust. But we tipped it over and it was fine, it was solid. The plaintiff's expert witness literally did not touch this piece. He looked at it and proclaimed, that is 60% rotten. This case is over. Now, I prodded with it, pounded with my fist on that, got a pocket knife, poked for some punky wood, which I found the yellow circle there shows an area roughly about 11 square inches of some punky wood. And that aligned up with this red arrow that is right below that old pruning cut, which is now an old cavity. Now, when you look at this, this looks really bad. And I was prepared to explain to a jury that this was just superficial mildew. That piece of wood had a lot of water in it. And when wood with a lot of water is set on concrete, concrete has that ability to actually wick that water away, that it was just mildew. But if there were some pictures taken as that piece was cut, this really could have just settled the question right then and now. So I was prepared to tell a jury all about, like Mathic's formula for off-center eccentric cavities and decay, T over R being greater than or equal to 0.30. But in the back of my mind, if you have someone on that jury that thinks that this is an evil tree, they might be thinking, look at this foreboding miasma of wood. This is what evil trees look like. This could really bode not well for the defense. So in the pressure cooker, testimony at deposition, and this part in particular, for those of you that are watching this, who are arborists, urban foresters, who have never been deposed before, or those of you who have been arborists for a while and are thinking about getting into consultation and being an expert witness, I hope this is some good information for you to consider. So testimony at deposition, just a few things, what not to do. Don't argue with the attorney. You'll never win that argument. Don't be flippant or arrogant. And in this case, one of the arborists was being deposed by the plaintiff's attorney, and she asked a really good, tough question. And he didn't really answer that at all, danced around it. And she asked that question again. He didn't answer it again either. And then she rephrased it, but asked the question third time, still did not answer in any direct way. So she makes this statement to him. And she says, "We're going to be here all afternoon, sir, if you want to play this game." He replies, "That's fine. I've got all day." You know, that doesn't help you, doesn't help anyone. I really believe that lawyers really like when, in this case, arborists, who are really not that schooled in how to testify at a deposition, I think they've got you right now, and you really have harmed your case. What to do? Tell the truth. It's as simple as that. Tell the truth. If you tell the truth, you can stand your ground. Be prepared to know the facts. When you're testifying, everyone has a right to an opinion, but that opinion must be based on facts. And there's a really big difference. So know the facts of the case, be prepared, and then be prepared for the actual, the scenario of sitting in a deposition. And by that I mean is, for the most part, we arborists, urban foresters, we can talk all day and very confidently about trees to our co-workers, our colleagues, our customers, our clients. But when you're in this scenario of a deposition, there's this really weird dynamic, because all of your words are being recorded, and oftentimes there's actually a video going. And that will really take you out of your game, because at some point, all of a sudden you start listening to your own words and you're kind of a spectator on the outside looking in. That's a bad place to be, because you're now the center of attention here. So you have to be really, really careful about going into a deposition. And here's the reason why. Depositions are known for, in the process known as discovery, all the evidence on both sides is being brought in. And opposing sides, the attorneys, will use the deposition as to probe, to see weaknesses and strengths of the other side's case. But it really is an attack on your credibility and professionalism. And I've had more than one lawyer tell me that, Mike, what this opposing attorney wants to do to you is make you look like you're the stupidest person in this room, make you look like you're inept, and that you're probably the most unethical arborist that's out there. This is what they really do. So I pulled a few examples, again, in terms of how we communicate and how we can defend ourselves in a really tense situation. So this example, and this is, to cue this up, this is the plaintiff's attorney questioning one of the arborists who was going to testify for the city. Is there anything else you can do to test for decay other than a probe and a mallet? Well, there are various devices you can use, such as a resistograph. What is a resistograph? It's a very thin, long drill that connects to a graph that gets printed out. Does the city of Billings have one? Yes. How often do you use something like that? I haven't. Would you be able to pick one up and use it tomorrow if I gave it to you? I don't think so. Now, I know this arborist. This is a highly qualified arborist, a lot of certifications, qualifications, great climber, great bucket guy, is one of the most ethical arborists that I know, hardworking arborist. He was kind of taken out of his game here, but he was telling the truth. He never had that opportunity to actually use the resistograph that the city bought. So really the attorney is using him in a way as a pawn to get back to the larger point of the city, is that you're negligent. You screwed up your duty. That a reasonable person, this standard of care, a reasonable arborist or some arborist who is overseeing other arborists, reasonably, if you had this really expensive piece of equipment, you would use that. You would train someone to actually use that. And it didn't happen. And now the pressure is on this arborist, to defend himself. Okay, getting back to the Tree of the Month article. So here's how some of the questions that the person who wrote this had to answer. And this is the plaintiff's attorney asking these questions. Now, there's one thing I read where you state that cottonwoods don't make for the best trees around houses and playgrounds. Do you see that part? Yes. Do you see what's immediately to the right of that tree in that picture? Yes. And what is that? That would be a playground. There's no way to defend that. This is tough. This is one of the main points that really caused a lot of concern for the defense. She further asked, because he was stating that these trees fall apart by the time they hit 100 years old, and the plaintiffs are arguing that the tree was already too old. In your experience, how often do cottonwoods, fall apart and die out before reaching 100? That's a good, tough question. She asked me that very question. I didn't agree with that. So that was my opinion. She said, well, but show me the evidence. So when I was deposed, I said, okay, good, let's get out of this stuffy room. Let's get in a car and I'll drive you around town and the county and I can show you 40 of these things. Really old cottonwood trees that are actually in pretty good shape. Here's another really good, tough question that she asked too. Would a significant branch failure constitute a tree falling apart in your opinion? That's a tough question to answer. Yeah, we can look at that and parse it over. And yeah, I can answer that if you have some time, if you're going over and having a couple of beers with your buddies and so forth. But in the heat of a deposition, in the really strange atmosphere of the deposition, this is a tough question to answer. And all those words that are recorded will probably be used in open court, where you'll actually have to answer it all over again. So the plaintiff's expert witness had contradicted himself at times during some of the reports that he had submitted that were entered into evidence, and also at deposition. And this one here caught my eye. And so this is just a screenshot of the actual printout. And I underlined a couple of these sentences. So this is the defense attorney is questioning the plaintiff's expert witness. And you also stated that the trunk was generally or is generally sound. How did you come to that opinion? Well, I felt that it was generally sound and that it was supporting the weight of the tree, had no visible fungi, and that it had no major cracks in the trunk itself. And then a few sentences later, he says, I was reticent to bore the tree and get the age. I did not want to introduce a wound point into a tree that was far gone. In my opinion, it was that unsound. Needless to say, this arborist here got really grilled on that contradiction. You're saying it was unsound, and now you're saying it was sound. What is it? This is a really tough spot for this arborist to be in. To the larger point, in terms of figuring the age of the tree, and again, where we have to take out off our arborist hat and put on our detective hat. In terms of figuring out the age of trees, we don't really need drilling instruments all the time to figure that out. And it's an old concept used in the social sciences. I'm an old sociologist before I got into arboriculture. It's called unobtrusive measurements. And it's a really useful tool for arborists to put in your toolbox because it doesn't take up any space, it doesn't cost anything. Here's how I determine the age of the tree. Again, thinking of this as like you're a detective or an investigative journalist, clues are really close to the scene of the crime. So This photo on the left, this black and white, it's an aerial photo showing what was then called the Billings Polytech Institute. They owned all that land that you see there. And at the time it was an agricultural college. The college is still there. It's called Rocky Mountain College. Over time, they parceled out a lot of that land. What you're looking at now are a lot of homes that were actually built in the late 40s, early 50s. And at the top left of that photo actually is what we call the rim rocks. It's this mesa-like plateau that's around 300 feet above the valley, Yellowstone River Valley. And the airport is on top of that. So I hope you can see that there's an inverted yellow triangle in this photo. That is the approximate sighting of where that cottonwood tree was. So this photo was taken in the 1920s. The incident happened in 2017. There is absolutely no way that this tree is 125 years or older. Now, I augmented that with just taking a few steps away from where the tree was growing, the cottonwood tree was growing, to a really nice memorial that dedicated Veterans Park. And if anyone had bothered to read that, you'd also get some really good information. It's actually a sad story. So at the end of 1945, in December of 1945, World War II had just ended. And 21 Army veterans are flying back from Europe, and they're on their way to Seattle, Washington to be discharged and start their lives again as civilians. And in a blinding snowstorm, the plane actually crashed, came really close. The airport's on top of the rims there, and they all got killed. And the plaque says that they were killed in an area very near here. That's in 1945. So there's no tree. Now, a tree could have been planted after the 1920s. That cottonwood could have been planted after the 1920s. But the city really didn't take hold of that property until the late 40s, early 50s. There'd be no reason for the college to plant a tree there because this is an open field. They're trying to grow crops there for experimental crops, right? So based on that, I felt that the tree could have been as young as 75 years old. At the most, 105, but more likely than not, this was a lot younger tree than what the plaintiffs were actually arguing. So as an arborist, when you're asked to look into forensics and investigative arboriculture, don't forget unobtrusive measurements. Start to wrap this up. A few slides ago, I mentioned that it's not a good idea to get snippy and arrogant and flippant with an attorney, in particular opposing attorney in deposition. And this is the question that the plaintiff's attorney was asking this arborist, and he didn't want to answer it. He just couldn't quite answer it. And here's her question. What I asked was, this green crown, that's not necessarily determinative of the health of a cottonwood tree. Would you agree or disagree with that statement? Now I'm asking you, anyone who's actually watching this video, to display that right now you're in a room of a deposition room. What would be your answer right now? What's your answer right now? She asked me that very same question. And I began with a lengthy reply, but I began with a 2-word sentence. It depends. So how does it all end? I spent 2.5 years of time from the incident that included over 3,000 documents. 48 hours before the trial was to begin, this is what happened. And 72 hours before I was to testify, this is what happened. The city and the plaintiffs settled out of court for $370,000. The city did not have to admit they were negligent. Was this worth keeping this tree? So I'll go back to talking about that, we have to accept some level of risk to enjoy all these benefits that the tree gives us. So if you agree with that, and I do, here's another question then. Did the total aesthetic, environmental, and ecological and social benefits over time match or surpass the monetary, social, physical, and psychological cost of causing severe harm to a person? Could our improved communication as arborists and urban foresters have maybe made this situation better, or at least help the defense, and I was part of the defense, win this case outright? We'll never know. Thanks for tuning in. I hope at some point in the future that some of this information might come to your mind and maybe help you manage your trees in a more safe way. Thank you very much.